So we've got Carl Gustafson, who is the bankruptcy section leader for 2022, helped organize this program, and Michael Primus from the law offices of Michael Primus, who is going to be our speaker today. And we're going to start off with something interesting from Michael. Take it away. Go ahead, Michael.
Okay. Well, first, welcome everybody. I'm glad you're here. I hope we can provide some meaningful content. I wanted to open the discussion of the malleable means test with a quote from Judge Jeffrey Cavender. And what the judge says is the cases are replete with phrases such as impossible choice, dueling absurd results, inconsistent provisions, and unfortunate omissions. It's no secret the final version of BAP-CIPA has been roundly criticized as poorly crafted, containing a multitude of typos, sloppy choices of words, hanging paragraphs, inconsistencies, as well as largely pointless but burdensome new requirements, overlapping layers of screening, mounds of new paper, and structural incoherence. To that backdrop, we're going to be discussing the malleable means test and room to move, things that could be done in a case to alter the outcome of the means test for your client. Now, having read that quote, I was going to turn it over to Carl, and he's going to introduce some of the material, and then it'll come back to me.
Okay, thanks, Mike. And really, thanks, Mike. Some of you might be coming based on, or coming to this CLE based on some advertising I put out on the listserv. It was a little bit late, but that was only because I just finished having my mind blown by the work that Michael did in preparing for this. You're going to get within the next couple of days the material that Mike's teaching from. It's about just shy of 20 pages of case reviews, and then it's winnowed down into practice pointers from all of those cases about the means test. My own background in this is I lost some staff during the Great Resignation, and there's nothing more valuable than having a really well-trained paralegal. So I was searching through all sorts of materials and putting together some training material for my own staff, trying to train up a new paralegal. And I started trying to research cases on the means test and gave up promptly because it was such a mess and there was so much out there. And I figured I would just train them later on the means test and some of the vicissitudes and roundabout parts. And then months later, Mike shows me some of his stubs, and I kind of blew my mind. It was what I had hoped to do, but given up because the task was too monumental. And I didn't even have the guts to get very far into it. And I think Mike got far enough into it that he couldn't stop and ended up actually finishing the task. So I think you'll be richly rewarded with the materials that come out of this. So enjoy the presentation from Mike today. I'm not going to take too much time, and then really dig into that material. I think that you'll find it useful both to change your practice immediately with the major pointers and also as reference material later on. I'm going to start out by talking about more of the income side of things, and then I'll hand it over to Mike, who's going to touch some of the other income issues, and then talk about the expense side of the means test. So I have a little slideshow that I'll present, and I hope I got the right screen here. I wish I could see all you too, but I know that one of the benefits of doing a Zoom CLE is that you don't have to show your face. You can be, vacuuming and whatnot. So I hope you'll enjoy these things and eating. Yeah. Do we have the right screen?
No, you gotta have your video on, and then you gotta share your screen.
Oh, have I not have video on? There's video.
There's video on now. You can share your screen.
Okay. So now I'm sharing this screen, and that says the Maleable Means Test.
It does. Slide,
right?
There you go.
Yes, it does. Yeah.
Okay, great. So here we go. The first question to ask in every case is, do I need to calculate income on Form 122, which is also known as the means test? I call Form 122 frequently because in Chapter 13, it's not exactly called the means test. In Chapter 7, it is. But first of all, is this a Chapter 13 case? If yes, you got to do it. Second, is the debtor an individual or a business? If they're a business, they don't have to do the means test. If they're an individual filing a Chapter 7 or 13, then they may have to do the means test. We're going to ask, is the majority of the debt consumer debt? If so, then they have to do the means test. This is the big out, is whether debt's consumer debt or not. The rest looks at military experience, and there is a military exception. It's extremely limited now because a lot of the exceptions timed out with regards to 9/11 and other things. So I think that only the military disability exception applies. And then we got to do the means test. In your initial consultation with the client to determine what their options are, you should be considering this majority of the debt being consumer debt or not, because it will really open a new doorway, or at least slice through a bunch of the limitations in bankruptcy that are imposed by the means test. Another idea is that Schedule I and 22 don't have to match. Now, this kind of is contrary to every objection to plan that you may have ever received from a Chapter 13 trustee. They seem to think it's objectionable whenever I and Form 22 don't match. I think that they use the shorthand to figure out, that either the debtor's being dishonest is the way they take it, but really they're asking what's changed. The reason they don't have to match is because they ask totally different questions. And Schedule I doesn't even ask the question, I argue, that it wants information about. So Schedule I says, well, the code says the debtor shall file a schedule of current income. That's it. Schedule I says estimate monthly income as of the date you file this form, which is pretty much saying schedule your current income. And that's fine. But I think what Schedule I actually wants to know is, what is your income going to be? And so although the code says nothing about, tell us about changes in your income, Schedule I has a section at the end of it that says, tell us about changes in your income. And when we're dealing with Chapter 13 cases, one of the standards for confirmation is that the plan needs to be feasible. And so the way we show feasible, we refer back to Schedule I, showing the current income. And current income may not make a plan feasible. So I don't know, Mike, do you ever omit future changes, known future changes in Schedule I where the means test doesn't apply just because the form itself isn't the law and the law doesn't ask for changes in income, just for current income?
It's a little bit of a self-serving definition on that. It depends on how soon the change is, how big the change is, how likely it is, nuanced with some self-serving notions that I may not want to bring up everything if it's not that much money or uncertain or a long ways down the line. The form technically asks for changes in the next 12 months, so think about that.
Yeah, so there's the malleability of the means test that Mike brought up with the title of this. What you do want to do, though, is make sure that your Schedule I shows some argument that can show, at least in the 13 context, that the bankruptcy plan is going to be feasible, and that'll allow you to confirm the plan. The other way that the changes form is often used is to explain any difference between Schedule I and Form 22. Now, Form 22 asks for a very rigorous examination of the prior 6 months average income. And the average income is income received during that time period. So you look at the date that the debtor received the wages, not the date that they worked. And then there are some other ins and outs of that that are going to be explored in the cases about what happens if it's commission and bonuses, et cetera. So a practice pointer here is just, if it's different, you should probably make it known to the trustee why it's different. But what gets me, and I guess this is just a personal beef, is when it's off by like 20 bucks and I get an objection, and it's just because the current income isn't exactly the same as their 6 month average. When should they match? Well, they should match when the debtor's income has been steady, okay? So if it's been totally steady, if they're in salary, which almost nobody here is, You look at California labor laws, and it's pretty hard to put anybody on real salary, but I and 22 should match, or when they're reasonably the same and you don't want to deal with the trustee asking you all sorts of questions about why they're off by 20 bucks. Here's an interesting question where the means test doesn't apply. So this is in a Chapter 7 context where the debtor has primarily non-business debt for the most part. Are you going to face issues if Schedule I minus Schedule J, meaning income that's not already allocated, shows that the debtor has quite a bit of money left over each month after paying for their necessities and their secured debt? I'd love to poll the group. I'm sure there are some war stories here, but what we have that's almost unique here in the Ninth Circuit is case law that says that there's no good faith requirement to a Chapter 7 bankruptcy filing where the means test doesn't apply. And this goes back to a pre-BAPSIPA Ninth Circuit case that said the following: bad faith is, well, basically the idea was that they looked at the confirmation requirements in Chapter 13, and they see in those a bad faith filing. And then they read that Chapter 7 has no such requirement. And they used the canon of statutory construction to say that Congress knows how to write a law that asks for good faith in filing. In Chapter 7, it asks for good faith in filing through this long definition that is essentially the means test. That's what determines good faith filing from bad faith. And so when Congress said that the means test doesn't apply where debt's primarily non-consumer debt, they chose not to impose a good faith versus bad faith analysis. And so as a result of that, Schedule I and Schedule J differences or surplus income showing on those schedules shouldn't matter. And they support it here additionally with this language saying that Chapter 7 should be available to any debtor willing to surrender all of its non-exempt assets, regardless of whether the debtor's motive in seeking such a remedy was grounded in good faith. I researched this quite in detail recently because I just filed a case and I expect the US trustee to find it fascinating. And so I'm relying heavily on this case to show that $4,000 excess income as not being an issue in her achieving a Chapter 7 reorganization because her debts are not primarily consumer debt. In the past, I've focused quite a bit on shaping budgets, looking at what current income is, and doing all the other things we do there with income and expenses. But past a point, you can only do so much. And so I'm relying on case law, which is probably what we should be able to do in every case. But sometimes bankruptcy works a little bit differently. There's also problems when past and future income doesn't match. So you have a debtor that just got a big raise. You have a debtor who's lost his or her job. You have a debtor who knows about some impending future event, such as retirement, et cetera. And so some of the things that we can do there with regards to the means test are lanning. And we're going to get into some of the lanning cases a little bit later. I think if you practice bankruptcy, you know what lanning is, but just generally it's a Supreme Court case in which, contrary to the plain language of the law, the Supreme Court found that substantially certain to occur future events can adjust the disposable monthly income determination of the debtor for purposes of what a Chapter 13 plan has to pay. So that's one thing that you can consider, taking a landing in your favor or trying to oppose or plan for another landing change that isn't in the debtor's favor. When counseling the debtor, you can counsel to wait and use a different 6-month period. That is entirely inside the debtor's control. You can hurry and file, so you can use this 6-month period. It's nice where a debtor's near filing to find a way to talk with them about the numbers before the end of a month. And then you can program whether, filing on Friday versus Monday will make a several $100 difference in their plan payment. Another thing you can do is a step plan. If things are going to change, you may have a DMI that's determining the repayment or some other issue that's determining your repayment. But if the debtor looks forward to something in the future that is better than today, that can allow you to take a lower payment today and do more in the future, or a stop plan or a conversion where you're going to stay in 13 until a certain thing happens and then convert out. Mike's information has quite a bit of case law about about conversion. And in the Ninth Circuit, a means test, at least in the Northern District of California, a means test is not required upon conversion to a Chapter 7 bankruptcy case. And we are, as in the Padilla case I just shared, we're the exception there. The exceptions don't always go in our favor, but in the case of conversion and not having to do the means test, we're the exception there. There's still plenty of cases that say the conversion needs to be essentially in good faith and that you can't just be sidestepping the means test. But if there's a change in income, then you're probably not just sidestepping the means test. There's something going on there. And then you can also look at whether the past and future income changes even matter. If your plan's being determined by 100% debt repayment, the means test isn't going to matter much. If there are substantial priority claims, they're going to suck up most of the income going into the plan, or secure debts that you're catching up, et cetera, then it may or may not matter that the debtor's income is going up or down. Another meaty part of the means test that is well worth digging into the case law, and Michael's handout has a couple pages on cases from all over the country on this, is the spouse's adjustment. So after the means test requires that you list all income from household expenses. In a Chapter 13, married debtors, even when separated, have to list the income from both debtors. And then you get to take deductions from them. But there's a way that that a spouse is able to adjust both their gross income and their income that goes on to Part 2, the expense part of the means test, by taking income that isn't part of, that they never actually get to use on their household or personal expenses. Okay. So here, the U.S. trustee's position is that the only things that you can exclude are withholding taxes from the spouse, which is kind of funny because you get a place to exclude that later on, but it might help you qualify as under median. Student loan payments from the non-filing spouse, prior support obligations from the non-filing spouse, and debt payment on which only the non-filing spouse is legally liable, and where the consideration for the loan exclusively benefits the non-filing spouse. So they say if you're using credit cards or used credit cards to pay household purposes, those shouldn't be deducted. Now, the U.S. trustee position doesn't take into account the California situation in which most debt is community property or community debt. But you may anticipate that they wouldn't take that into account in considering examinations of the debtors taking of those deductions anyhow. They may well follow the national standard. As a contrast to the U.S. trustee position, which is quite limited, we have the cases. The cases don't excuse refusal to cooperate by the non-filing spouse, but they do show that quite a few other deductions have been included. So some of them are payments on a truck loan made for work by the non-filing spouse, payments on property taxes for property owned by the non-filing spouse that's not used for family or household purposes. The cases on a house that's titled in the non-filing spouse's debtors, the non-filing spouse's name, are very mixed, where the property is used for the debtor's household or family purposes, so the debtor's living in the house. But if you go down a little bit further, you got mortgage, utilities, travel, and other things by the debtor's spouse. And I'm sorry, this is kind of an ugly chart. So we've got student loans, and then Mike suggests cigarettes that the non-filing spouse uses if the spouse isn't a smoker and isn't sharing in them, and other expenses that never make it to the family household. So you'll find in the cases, and there are quite a few more cases than this is just a sample, that there are a lot more non-filing spouse expenses that the courts have found. You may find that the U.S. trustee objects to those, but if you've got case law and they don't, go to it. And that is a great reason why we should get the case law together in one extensive compendium that we can refer to and use to help shape, hopefully, if we're consistent, the U.S. trustees' inquiries and educate them as well so that we do less busy work in order to help our clients get what they deserve. And also to better represent folks with regards to the means test and know what's actually supposed to happen. And with that, I'm going to hand it over to Mike for the balance of the time. And Mike, thanks for that resource and look forward to watching you share the practice pointers with everybody.
Thank you. Thank you, Carl. Well, one thing, and let me see if I can screen share here and get to what I want. Okay. Can you see my screen there?
Yes, we can.
Okay. The malleable means test, room to move. Is that what you see?
Yes.
Okay. Very good on that then. Well, these are the materials. We're going to provide these at the end of the time, but to go through some of this, let me see if I can just got in mind here. One question that may arise early on is the sniff test. Wouldn't somebody say to Carl or to a judge, this just doesn't pass the sniff test? This just doesn't seem right that you do these things.
Sorry to interrupt real quick. Can you increase the size so that the text takes up the whole screen for some folks?
I think I can, yeah.
Maybe harder. And also, while that's happening, audience, feel free to submit questions. I'll be monitoring the questions and we'll see what how many of those we can take.
I think go down below and increase the size of the bottom right-hand corner.
In Zoom?
No, on your thing where it says 130%. You're close. Bottom right-hand corner of your Word screen.
Oh,
there you go. Keep going.
Better?
Oh, I don't know what you did. That's good though. Is that better for you, Carl?
It's a little bit better. I think, Mike, if you push escape there, there's a zoom button. It's just above the clock on your monitor. And we got a question regarding non-filing spouse.
Oh, here we go. Sorry about that. Okay.
So we got one question regarding non-filing spouse who's separated. I didn't include their income, did not think it was necessary.
Okay.
Right
and the answer there is that their income isn't necessary in a Chapter 7 bankruptcy case, but the income for a separated spouse is necessary in a Chapter 13 case. Back to you, Mike.
Okay. Well, the first thing I wanted to touch on before we go into too much detail is the sniff test. Doesn't this just seem too good to be true? Some of the things we're going to be talking about, changing your budget or looking at it this way or that way. And what I want people to be aware of is some cases here. First, the Supreme Court's case, Milovitz, Gallup, and Milovitz, interpreted what was it's Section 526A4 as part of BAPSIPA that purported to prohibit attorneys from giving advice, advising people to incur debt in contemplation of bankruptcy. Well, they looked at it, the circuit court had looked at it, there were different readings of it. What they came down to is that attorneys would be allowed to give advice if it was going to be for a legitimate purpose, including things like refinancing a mortgage or getting a reliable car. That somebody's got their mic on.
And I think you're off mute.
Okay. That we can advise people to refinance a mortgage or to purchase a reliable car if we can get a better interest rate. What they were primarily concerned about is loading up on debt that was intended to be discharged in a bankruptcy, including attorney's fees, and there's some cases on that. Now, that's what the interpretation of Section 526A4 is. We're allowed to do that we're not supposed to be telling people to load up on debt that we intend to have discharged. And one recent case that was interesting on that involved a person who purchased a car shortly prior to a bankruptcy, said they were going to reaffirm, and then did not reaffirm the car. And the lender challenged the discharge and said essentially they loaded up on debt by not reaffirming they're discharging the debt. And that sounds like it's fraud. That's a dirty deal. Well, they lost on that adversary. It was the lender bought an adversary, and they lost on that. The court said that failing to sign a reaffirmation agreement was not the same as loading up on debt for the purpose of having it discharged into bankruptcy. That's a little side note with that. Now, a couple other cases about this sniff test. I think most of us are familiar with Welch. That's a Ninth Circuit case from 2013 that essentially says courts are not allowed to use bad faith as a separate test from the means test to determine what a Chapter 13 plan should look like. In some parts of the country and prior to Welch, there were judges that wanted to kind of use their notion of good faith along with the means test, along with the budget as kind of the 3 points of light that a judge would look at in determining whether a plan should be confirmed or not. Welch said, essentially, we're going to use the means test and we don't use the notion, the subjective notion of the judge about good faith or bad faith to alter the express provisions of the means test. The other case regarding the sniff test, and I'm going to dig into this in a little more detail, is a Ninth Circuit BAP case from 2000 that talks about changing charitable giving either immediately prior to or immediately following the filing of a bankruptcy. And I wanted to go into that in a little bit of detail. In this case, the Kavanaugh case, and let me take a look. It's out of Montana. The debtors filed their Chapter 13 and proposed to pay for 39 months. And shortly after filing, the husband got a promotion. So the trustee said, well, you need to amend your schedules to reflect the promotion. And the debtors amended their schedules, but they also added a charitable, also said they wanted to begin giving money to their church, a charitable deduction, so that their ability to pay did not change, notwithstanding the promotion. So husband gets a promotion. The trustee says you need to amend the schedules. They say we're going to amend the schedules. The trustee expects the payment's going to go up, but it doesn't because they say they want to give the money to their church. Well, the trustee says this sudden charitable spirit is unnecessary. It's not essential. This isn't right. It's bad faith. You can't do that. Well, the bankruptcy court looked at the statute, conducted a hearing, and found that the debtors, as far as the bankruptcy court was concerned, were acting in good faith. The husband had explained that they'd wanted to give money to their church, that the church had been there to help them financially and in other ways in their time of need, and that it wasn't a complete new revelation, although it might appear to be that way. So the trustee appealed it to the Ninth Circuit BAP, and the Ninth Circuit BAP upheld the bankruptcy court and said essentially that when it comes to charitable giving, Congress did not impose any time restrictions. The restriction is that the maximum of charitable giving is 15%, but they didn't choose to impose a timeline, and the court declined to create one. That was the bankruptcy of Kavanaugh. So when you look at that and we talk about the sniff test, when we're working with this malleable means test, we've got some law on our side from the Supreme Court talking about what we can and cannot say, to the Welch case that says the court can't use bad faith to override the express provisions of the means test, to the Kavanaugh case talking about changes in charitable giving either on the eve of bankruptcy or immediately after. So that gives us a lot of reason to have confidence that we can alter our client's situation if it's helpful and declare those things. Now, in the materials, I know you don't have them yet, we're going to talk more, and I want to go through some of this. As Carl mentioned, the non-filing spouse is a huge opportunity. It's room for us to move in a lot of ways. The notion of a non-filing spouse is viable in both Chapter 7 and Chapter 13. Now, there's a huge difference there. In Chapter 13, and Carl mentioned this, we're required to disclose the income of a non-filing spouse, which is obviously problematic some of the time if the non-filing spouse doesn't want to cooperate. In the materials, I cite to at least one case where a non-filing spouse refused to cooperate, and essentially the court said the law is what it is, and that their refusal to cooperate doesn't excuse the disclosure. So the debtors had to try and figure that out. In Chapter 7, we're not required to disclose all of the non-filing spouse's income, just what's being contributed to the household. But not disclosing it doesn't mean that let me say that again. The fact we don't disclose the entirety of the non-filing spouse's income doesn't mean we don't include what's contributed to the household, but it is a lot easier procedurally and from a practice pointer perspective to get information about what is being contributed to the household from a non-filing spouse that simply doesn't want to provide pay stubs or have any discussion whatsoever. We can at least tell what's coming into the house. Now, Carl mentioned some of the U.S. trustee positions, but when we talk about a practice pointer here, if you can see my cursor, the non-filing spouse is really helpful if you navigate it properly and ask the right questions. The non-filing spouse may be putting money into a 401k. They may have specific medical needs. They may, as Carl mentioned, they may smoke. And there's a handful of things that they can do that are strictly personal expenses that would not be contributed to the household. One overriding principle is to remember that a non-filing spouse is not necessarily required to live a budget in accordance with the means test. Now, that seems like an odd household where the one lives high on the hog and the other one's under this strict scrutiny, but that's what the cases say, is a non-filing spouse is not required to live under the strictures of the means test. Similarly, roommates and other occupants wouldn't be subject to the means test. Give me just a second. Let me take a look at a couple things here. Now, and in the materials, I'm going to give you a lot of these cases, but with these non-filing spouse cases in Chapter 13, there are cases talking about the non-filing spouse's car payment or vehicle payment being excluded because it's used exclusively by the non-filing spouse and may or may not be of any particular benefit to the household. Now, you could imagine the non-filing spouse's vehicle being used for the household in some fashion, or in some cases, they say that it's found not to be. The cases also look at who is liable on a vehicle payment. If it's the non-filing spouse exclusively, that helps. That doesn't carry the day in most courts, but it certainly helps. Now, I think Carl mentioned there's one case out of Florida, it's a 2019 case called Campbell, where the non-filing spouse was paying the property taxes on 6 vacant parcels of land that the couple owned. Well, the property taxes on these vacant parcels of land were not household expenses. There was no house on these properties. So that wouldn't be a reasonable expense for the debtor, but the non-filing spouse was allowed to do that, and that reduced the non-filing spouse's ability to contribute. Let's see. Non-filing spouses certainly can pay court-ordered payments. That money doesn't come into the household, is available to pay household expenses. Let's see. In an interesting case called Shake, and S-H-A-I-K, if I recall it right, there's some verbiage talking about defining a household and whose income is going to be counted. Now, right now we're talking about a non-filing spouse, but it's going to expand to girlfriends, boyfriends, roommates, and others. That's my first practice pointer. Is I want you to think seriously about non-filing spouses, ask them what they do and don't pay, and just think about that, because there's a lot of money that can be excluded. Now, the next practice pointer here I've got is time to trade in that gas guzzler on an EV, an electric vehicle, or a Prius. I think most of us realize that after the Rodriguez case, vehicle operating expenses are capped, notwithstanding long commutes or other things. In the Rodriguez case, which is a 2020 BAP case cited in the materials that Carl and I both are familiar with, the debtors lived, I wanted to say it was in Brentwood or Oakley, and the husband commuted all the way to Oakland. He worked at Kaiser and had varying shifts. There was no meaningful way to get to and from work on public transportation. They had 4 kids and had a couple of big cars, and their transportation expenses were sky high. Well, the BAP looked at that situation and said, well, Congress has chosen to limit vehicle operating expenses, and that's where it's at. There is no alternate way to say it's not a special circumstance, and there's no wiggle room on that. As we know, the means test does allow for the deduction of car payments. Now, there's a limit on that, but as a general proposition, they allow the deduction of car payments. So what if you have somebody with really high commute expenses? Well, the means test is not going to respect high gas costs or long commute expenses. It is going to respect a vehicle payment, and that's where I get the practice pointer, trade in the gas guzzler and get a Prius. That the system would respect the payment on a Prius or an electric vehicle, but they wouldn't respect high gas prices, which of course right now is a huge issue. Okay, and in the materials, I've got some cases on that, also talking about things purchased prior to bankruptcy, and a couple little interesting notes while we're talking about purchasing cars prior to bankruptcy. The Rodriguez case talks about the full vehicle deduction being allowed despite the actual payment being different. So if the car payment is less than the means test allowance, you get the full allowance. There are court cases that talk about title loans. If there's one payment left, if the title loan is $80 a month, but the allowance is north of 500, you get the full allowance. There are court cases that I cite in the materials that talk about purchasing a car shortly prior to Chapter 13 and then cramming down the interest rate. Now, in Chapter 13, if it's a car that's purchased within 910 days, most of us know you can't cram it down, as you can't rewrite the balance on the loan through Chapter 13, but you can cram down the interest rate. And courts have generally allowed that, even if the car was purchased a few months before a bankruptcy. So if somebody bought a car with a 23% interest rate, they could put it into Chapter 13 and offer to pay the full contract balance at 6% or something like that. Of course, we have to factor in trustees' fees and attorneys' fees, so that the reworking of a car payment alone, in my mind, would never justify Chapter 13, but if you're going to Chapter 13 anyway, it's something to be aware of. So practice pointer, trade in gas guzzlers, and think about getting an EV or a Prius. The next practice pointer here is to clarify the budget with co-occupants of a house. When we're talking about unmarried couples or roommates or grandparents, oftentimes the arrangements are not very clear. If we're talking about the burden of proof being on the debtor and our obligation to disclose things, one easy way to start to do that, particularly if this is not a rush case, is going to be to say to them, sit down and hash out a budget. Who pays what? If the debtor says, I pay the best I can, my boyfriend gives me what I need to make ends meet, he's been helping me, that's not a good way for us to go to court. What I would tell that debtor is sit down, solidify things. If your boyfriend is going to help, we just need to have some continuity around it so we can answer the question, how much help do you get? So that's the first thing, is to try to clarify things with co-occupants of a house where they're oftentimes family members and it's a little bit loosey-goosey. And let me scroll down here just a little bit. Okay, with co-occupants, I'd like to have them avoid commingling funds or joint accounts with the one exception if they have a joint account that they call the house account, where we both put our half of the rent into the house account. We both put our half of the utilities into the house account. That can work well, but it gets messy if they commingle funds from lots of different sources. Then you try to talk about whose is what. So that goes back to setting up a budget with co-occupants about who's going to pay what, trying to stick to it. Give me just a second here. Now, one case cited in the material is called Broadbent, and that's a case out of Idaho from 2015 at 531 BR 840. And what it stands for is that nowhere does the code require a live-in significant other's income to be counted in analyzing a Chapter 13. And what the court said is it was going to decline to treat a live-in girlfriend like a non-filing spouse, and failing to include that person's income, like full disclosure, would not be bad faith. Now, if we looked at the live-in girlfriend, that's different from a spouse, and the disclosure requirements are for a non-filing spouse. In this case, the court didn't expect disclosure from a live-in girlfriend, but if we look at the substance of it, it's going to be more like Chapter 7, where whatever this other person is contributing to the debtor's household should be counted. Now, I said the debtor's household, and we're going to talk a lot more about household size and whose household is what. We'll get to that in just a minute. My next practice pointer is to look at corporations or LLCs. Single member corporations or LLCs give the debtor an opportunity to alter how much their income is. Now, Chapter 7 trustees often like to try to overlook the corporate formalities. When it comes to the means test, courts are torn about that, but disinclined to do that. They acknowledge in some of the cases that a self-employed debtor or a debtor with a corporation can pay themselves what they want to pay themselves and declare their income, and that can be done in a self-serving way. But that is the nature of a corporation in our country. It's a separate legal entity, and its obligation is not necessarily to maximize distribution to employees. It can have its own obligations it needs to pay. It can hold on to some money in the corporate account. Now, aside from exemption issues, that's essentially allowed. So if you have someone with a single member corporation or an LLC, and you're looking at means test issues, think about how much can they distribute, how much do they need to distribute, what's available. Now, in the vast majority of these cases, the way things are handled is what I call profit sharing. And that's where the corporation or the LLC shares any profit that it has with the owner. Too much money is rarely the problem. It's typically that the company's not making enough money and can't afford to make payroll or can't afford to distribute. But in the happy situation, the company has enough money, it may think about how much it really wants to distribute. Let's see. Now, one interesting case, and it's in the materials, the bankruptcy of Lafferty, talked about what was called phantom income. And if you've spoken to an accountant in some detail about this, some of the time they're going to recommend that the single member of the corporation or LLC may loan money to the company, and then when the company pays them, it's loan repayment, not taxable income. But loan repayment in this bankruptcy of Lafferty was referred to as phantom income and was not considered as income to the debtor personally, even though it was money coming into the debtor's account from the company. It was considered loan repayment, and the debtor had a claim against the company. Some courts have tried to kind of overlook the corporate formality. Let's see here. A court in the bankruptcy of Havens from Massachusetts tried to talk about personal expenses paid out of the corporation ought to somehow be considered income to the debtor. That makes some sense, but it doesn't necessarily hold water. A better reasoned view is the bankruptcy of Romero, which comes from the Southern District of Florida. It's a 2013 case where the court said that income from a business is irrelevant. What counts as income made available to cover household expenses. There's another case that refers to business debtors, including profits, not gross receipts. So that's room to move if you have that circumstance in terms of what's distributed to the individual and what becomes income. Now, the next practice pointer I want to talk to you about is student loans. There is no per se rule that student loans are consumer debt. Some student loans are, some aren't, and it can be factually driven. A couple of questions to ask people would be, did you have any experience in the field prior to going to college or to school? A lot of the cases talk about if the school expense was to further a business opportunity or an existing career aspiration or existing job, that can make it non-consumer debt. So you think about it, and if somebody went to nursing school, maybe you ask them, hey, did you volunteer around a hospital? Did you help out? What have you done to care for people? Were you a caregiver? Did you do IHSS? Have you done some things before you went to school? Because that could render these student loans non-consumer debt. Now, I think most of us understand, but to be clear here, non-consumer debt goes to the issue of whether the means test applies or not. We're not referring to the dischargeability of student loans. That's a different discussion. What we're talking about is whether we can say student loans qualify as non-consumer debt to help us avoid the means test entirely. Okay, give me another second here. Yes, sir.
Just while you're getting that, one of the messiest issues I've found in the means test was the student loan. There's so many different rationales. Some courts have found that if you spent it on books and living expenses and food while you were studying, then it's consumer debts. But if you spend it on the education, it's non-consumer debt. Others have talked about the feeling that you had and whether you had a profit motive or not. Another has talked about whether it prepared you for an existing opportunity, and that's kind of what Mike was referring to. Another court talked about whether it was something that could be estranged from you or not, like whether you're enriching yourself or getting a degree that only basically had value within a certain limited context. The courts just have like nothing to go on in this, and to me, I think this just question of what is and isn't personal or consumer debt is embodied by that quote that Mike read at the beginning. There's no good guidance on it, and so courts have found all over the place. However, to get out from underneath the means test, there's a whole lot of power in that, right? So it's worth exploring.
That's correct. The cases are all over. Pre-BAP-CEPA law is applicable to the distinction between consumer and non-consumer debt. When we talk about consumer and non-consumer debt, it actually comes up in a number of areas, but the tests and the rationale in the cases are being applied across the board. When I say a number of ways, of course, in the means test, but also with the co-debtor stay. The co-debtor stay applies to consumer debt, so cases interpreting consumer debt for that purpose seem to be, for the most part, equally applicable. 722 redemption is for consumer debts. 722 cases talk about consumer debt, again, seem to be equally applicable. Attorney's fees under 523D, that has to do with consumer debt, and those cases seem to be applicable on the issue of what is or is not consumer debt. Now, one case that's not in the materials is a brand new case out of Georgia called Townsend versus Ruff, R-U-F-F. And it was decided March 31st of 2022. And the judge goes into a lot of detail in this case about different theories for how this ought to be looked at, what the different circuits have said, and how this judge thinks it ought to be looked at. So brand new case, bankruptcy of Ruff, R-U-F-F. So that one's not in the materials. Now, let's see. I agree with what Carl said. Some with student loans, some courts are going to look at a profit motive, an existing business opportunity. One court said, where the debtor said he wanted to own his own business and he went off to school, that was enough of a profit motive. He hoped to start his own business, and that's a profit motive. And he was investing in himself, and that sounded fine. Let's see. One court in Florida in 2019 created more than found, a rebuttable presumption that student loans were consumer debts. That's the closest I've seen to anything that would constitute a rule. There are plenty of cases that say there is no per se rule about that. I think most of us are aware that the means test, and we're going to talk about household size, but that the means test in the bankruptcy system, generally speaking, allow people to support kids and the elderly in a lot of different ways. And I've found that asking some questions can really help, because people oftentimes don't see their grandmother being in the house as germane to any of the things that we were talking about. They oftentimes don't want their kids or their grandparents to know about bankruptcy, and they don't bring stuff like that up. Now, in the paperwork, we routinely ask about people that are in the house, and I would just encourage you to ask a few more questions, because some of the time there is a family member that had wanted to move in and they told them, don't do it. We can't help you. You've got to go with your other sibling. Well, maybe if you've got a means test issue, now's the time to be more benevolent and allow Auntie to come move in with you than you might otherwise have had in mind. In terms of supporting people, if we look at the forms in the petition, it does not contemplate partial custody of children. Now, in a lot of what we're talking about, there's not a lot of circuit level law. There is a circuit case, the Zimmer case, that does talk about allocation of children when there's partial custody, but the forms don't really contemplate that. I think Carl and myself are going to consider partial custody as a full dependent on the theory that they've got to have a bed and other things. You can't heat half the house. So if the kids come and go half the time, you call them what they are, or you count them as a dependent. Now, I'd said, and I think we all realize, that household income has a huge impact on the means test. And let me turn to a couple things that I want to highlight here. With household size, the courts have used 3 different tests, one being the economic unit approach, which is the dominant test, and the newer cases all seem to be gravitating to that. The Census Bureau test, which refers to heads on beds, which seems to have faded out after about 2009. Early after BAPSIPA came into effect in 2005, it was the Wild West with this, but the heads on beds approach is disfavored and very few courts use it, but it is out there in some cases. The third approach is the income tax dependent approach. And that approach doesn't seem to fit things very well. That approach, a court is going to look at, if you claim somebody's a dependent on your taxes, that would be the factor the court would look to in determining household size. But of course, we know taxation and means testing are 2 separate things, and that divorced people sometimes will have an agreement that says husband takes the kids on his taxes in even numbered years and wife in odd numbered years, or things that would make that approach misleading. And courts have seen that. So the dominant approach, and the one we need to be ready to use, is what's called the economic unit approach. That flies right in the face of a lot of what BAP-CIPA was trying to do when BAP-CIPA was put into place to limit judicial discretion, because the economic unit approach gives a judge a chance to look at who lives here and who's codependent, and it's pretty subjective, the size of the household, using the economic unit approach. Let's see. And I guess I'd mentioned that Zimmer case, which is actually out of the Fourth Circuit, and it'll be in the materials we'll get for you. Now, a couple things to look at. And this is in the materials, there's a case called Collins out of Alabama. It's a 2021 case where the debtor was residing with parents, and the parents' income was not included in the debtor's CMI, even though the parents were contributing. So the court in that case found a household size of 1 where they weren't completely intermixed with each other. There's a case of Duran out of Southern District of California. That was an adult daughter living in a home, was not going to be treated like a non-filing spouse for disclosure and for contribution purposes. There's a case from New York that involved a 22-year-old daughter living at home, was considered a dependent, and they looked at her income and what she was doing with it. Now, with these, let's see, the case of Bostic, which is out of Minnesota, talks about roommates sharing expenses. In that case, the roommates had separate leases, so the rent was not one big household obligation. But you can imagine with the wrong judge, for example, a fraternity house might be found to be a household of 12. Everybody's supposed to chip in all their income and disclose everything, which would be crazy making. But you can envision that with this kind of an approach that it might be done. Let's see. Now, some of the really interesting things, and we're going to get into some of the exclusions, but Social Security, and I guess I should move down to that with household size. We want to look at the economic unit approach. You want to talk to people, ask them what does or does not happen. This ties into what I'd said earlier. If these are roommates or boyfriend, girlfriend, it's a little bit, he gives me what I need when I need it, or that kind of thing. Have them sit down, work through a budget, and then be ready to tell the truth once they work through a budget. If the rent isn't divided equally, that's okay. There's no requirement that the roommates be 100% fair to each other. Obviously, oftentimes roommates are going to say, well, one pays more because they get the parking space, or one pays less because they agreed to deal with the trash or what have you. I think the main thing is to create some kind of a solid budget so they can answer honestly about who pays what if it had been wishy-washy in the past. Let's see here. With supporting charity, we talked earlier about that Kavanaugh case and the idea that the statute does not require a specific time frame for when charitable giving must have occurred. In that Kavanaugh case from Montana, the judge kind of used a good faith test, and the husband testified that he wanted to start giving to the church and that his wife had in the past, and the judge felt like they were acting in good faith. Now, that case pre-existed the Welch case, which we talked about earlier, that Ninth Circuit case that says the court can't use good faith, bad faith to override the express provisions of the means test. So with charitable giving, can they start it? Yeah, they could do that. That would reduce their ability to pay. I think they should legitimately do it, be able to document that. I'd want them to do it in good faith, but I think if push came to shove, good faith really isn't supposed to be the test on that. There's an awful lot of religious freedom, and the cap is 15%. Now, not all courts see it that way. Let me just, there's a case out of the Eastern District of California, and let's see. It's in the materials, but in that case, since there was no specific timeline, the judge, I think it was Judge Clement, looked at charitable giving on a 3-year average and limited the debtor's deduction to their 3-year average for charitable giving. So that flies right in the face of Kavanaugh. It was from the Eastern District of California. The judge didn't make any reference to Kavanaugh whatsoever. So I don't like that case at all. I think they just made that up out of nowhere. 3 years is a lot longer than anything else we look at, and with no good reason as far as I was concerned. Okay. We talked about household size, supporting charity. Okay, the converted case. And Carl mentioned this, that some courts say that you have to file a new means test when you convert from Chapter 13 to Chapter 7. Other courts do not. One thing that is clear is the 6 months is the 6 months prior to the initial filing of the case, not the 6 months prior to conversion. Now that can mean if the person had been in Chapter 13 for 2 or 3 years, the 6 months prior to filing really doesn't shed any light on their current situation at all, but that is what the 6 months that we're looking at. That's the test. Technically, the Chapter 13 means test is different than the Chapter 7 means test. I think we all realize that. And some courts think there needs to be a new means test, but others don't. In the Northern District of California, the cases are, and Judge Jelen has one of them that was actually my case, the Ryder case from 2008, where he said that the statute doesn't require a new means test on conversion. Now, the judges that don't like that think that people are going to try and game the system. They're going to file, they're going to file Chapter 13 and convert it 2 weeks later and try and dodge the means test. I don't know to what extent that strategy has been utilized, but that's what they are concerned about. Let's see here. Now, another big topic when we get into income is, let me get to this here. Okay, we talked about car payments. Yeah, the Supreme Court affirmed ransom, which was a case that said the actual payments allowed, even if there's only one car payment left, it's still allowed. Now that could get into a Lanning thing where the budget going forward obviously is not the same as it was, but that's what they'd said, is you count that even if there's one payment left. There are courts that talk about title loans taken shortly prior to bankruptcy and counting that. The bankruptcy of Lopez, which is out of the Eastern District of California, does talk about title loans and non-purchase money loans taken even days before filing. Payments made by a debtor can count even if the loan is not in the debtor's name. So you can envision they need to get some money, they have their aunt help them or something like that. But that case talked about allowing it even where the loan wasn't in the debtor's name. Now, in the Ninth Circuit, we're not allowed to count voluntary retirement contributions as a deduction from the means test, but in many circuits you can. In the Ninth Circuit, we've got Parks and McCullers. I think it's called McCullers. Yeah, McCullers. And they basically say you can't do that. McCullers was a Northern District of California case from 2011 that said you can't pay anything into voluntary retirement. But other circuits do allow it. Talked about that. Now, one other thing, and let me just get to this that I want to talk to you about that's a big one, is Social Security. Actually, let me step back and let me give you, we've got a few more minutes here, not too many. We talk about non-consumer debt. Let me go back to that. We talked about student loans. Personal guarantees of business debt are non-consumer debt. Personal injury claims Claims from car accidents are non-consumer debt. Intentional torts can be non-consumer debt. Medical, now there's a case from a 2020 case out of, excuse me, the Southern District of Ohio talking about it. Emergency medical treatment is not voluntarily incurred and is not consumer debt, but routine medical treatment may be consumer debt. So emergency medical, non-consumer debt. Attorney's fees, excuse me, can be non-consumer debt depending on the nature of the underlying claim that's being dealt with. Now, this was interesting. This came out of the Eastern District of California. It's called Renteria, and it's a 2011 case in the materials. Attorney's fees related to domestic violence and paternity were consumer debt. Well, a lot of the cases talk about consumer debt as household expenses. Well, I didn't think domestic violence is a household expense. That seemed really strange to me, but that's what that case said. Now, for income, when we talk about income, there are some dicey issues when the debtor sells assets prior to bankruptcy. Does that count as income, or is it the liquidation of an asset? It's not income. If debtors sell things in the ordinary course of business, that's probably going to be income. If they sell other things, they sell an old car, that's probably not going to be considered income for means test purposes. It's not regular. It's conversion of an asset from one form to another. There's a split with inheritance. Some courts are going to consider inheritance funds to be disposable income, and other courts not. Bonuses. Now, there's some troubling cases in the area of bonuses where some courts have used Lanning to look beyond the 6 months and count a Christmas bonus outside the 6 months as disposable income. Other courts have looked at bonuses in some circumstances and said they're just too speculative. You can't count future bonuses because who knows what'll happen. Well, most debtors' attorneys are of that mindset that future bonuses are too speculative, so we don't count that. Loan proceeds are not considered income. So if you take cash advances, the fact it's a deposit in your bank does not make that income. There's a case out of New York talking about that. With mileage and expense reimbursement, there's some splits in that. Generally, they're considered income to the debtor and they can be deducted further down, but it can increase the commitment period because it's considered income. Now, in one case, a 2016 case out of Utah, the debtor was a salesperson at CarMax, and they were allowed to drive cars around, kind of drive a car off the lot home every night. And that was considered an in-kind income that did not count because it wasn't cash that could be used to fund a plan. Let's see, we talked about that. Now, when we talk about calculating the amount, there's some strange strange wording that can be a little bit difficult to navigate, where the income needs to be received, derived, and earned in order to count. And courts talk about what it means to be received, what it means to be derived, what it means to be earned. I think that's relatively clear unless you get into a situation with a real estate agent where there's an escrow that's opened and it might close. You talk about when was it received, when was it earned, when was it derived. There's at least one case talking about the timing of payroll where the pay cycle ends, but a person doesn't get paid till 2 weeks later, and dicing and parsing that. So there are some issues, and it's in the materials about received, derived, and earned, and proration of income. I think we talked about self-employed. Now, one source of huge contention, I guess, and splits would be Social Security. Some courts are going to say Social Security, well, they all say Social Security is excluded. But then we need to get into the details of it. Does it need to be the debtor's Social Security to be excluded? What if it's a non-filing spouse's Social Security? Is that excluded? What if it is a live-in grandparent's Social Security? Is that excluded? Well, some courts are going to say when the grandparent receives the money and chooses to contribute it to the household, it becomes household income, even though it was Social Security in the past. Other courts are going to say, no, it was Social Security and it still is, and that does not count. So there's a big fork in the road on Social Security. There's no circuit level cases on that. So if you have a grandparent or someone else is getting Social Security, a non-debtor in the household, that is definitely room to move, whether that's counted or how it's looked at. And I've got some cases in the materials talking about that. The case I'd mentioned earlier, Shake from the 10th Circuit, BAP, it's a 2020 case, discourages courts from using an expansive definition that would bring in college students and other adults splitting expenses.
Mike?
Yes, sir.
I think we're almost at the end of our time.
Okay.
And if this was just thrilling to you and you're like, these questions I had on my mind, they're finally being answered, which Anne probably won't let us talk for another half hour, but.
Okay, I got to talk for 30 more seconds. I promise I'll shut up, Anne.
Yes.
Okay. Retirement loans can be deducted from the means test. And there's a case out of Virginia talking about a 401k loan taken shortly prior to filing used to pay mortgage arrears and attorney's fees. And they said that was fair enough. It got to be deducted from the means test, even though it was taken shortly prior to. It looks like they're kind of rigging the system. Unemployment. In the Northern District of California, we have been able to not count unemployment as income. In most of the country, the majority view is that unemployment does count as income. It's not distributed through the Social Security Administration. So we've been very lucky through enhanced unemployment and COVID to not count that in the Northern District, but that is the minority view. And I'll leave it at that. I think we've covered most of the nuts and bolts for sure.
Fantastic, Mike. I wish that we had this in person so you could hear the applause. I know I was applauding, reading the materials by myself. And when you get these materials, you'll be able to dig into these cases and you'll see how much is there and how many of your questions you've had that Mike was able to find answers for in the cases. And how blessed we are really in the Northern District of California to have so many laws go our way. I wish we had the retirement go the other way. And I challenge one of you to talk to me if you want to challenge and try to make our court soften on taking retirement as deductions. There was one judge who went rogue and defied the BAP up in Washington. And he's been cited many times positively for doing so. So I was looking for the case for myself. Look at Mike, you're getting applause. So let's do that one next. But in the meantime, let's engage with all the case law that we got. Back to you, Anne.
Great. Thank you, guys. Everybody, we'll get things out to you. Yep, there's the applause. Thank you, Corinne. And if there's any additional questions, Mike, can they get in touch with you or
sure.
and Carl? Okay. And we'll just get everything sent out and go from there and look forward to the next program.
Well, thank you, everybody, for participating.